Good afternoon, everyone. My name is Sarah Pinder and I'm the Joint Head of the Immigration and Public Law team. And I've got the pleasure to introduce my colleague Bronwen Jones, who you're going to be joining for this wonderful session this afternoon on local authority duties to non-British children. It is the second instalment in our spring webinar series, so thank you if you are attending again after last Tuesday's session. This webinar is recorded, so I just have to go through a few housekeeping matters. It's recorded. If that is a difficulty for you, if there's a problem with that, please contact us either by posting something in the chat box or by contacting us by email on the details that you have through your booking information. But otherwise, I'm going to be short and sweet. The webinar is going to take place shortly. It's going to last no more than an hour. And there will be an opportunity to ask some questions via the Q&A box. So if you can, keep your questions to the Q&A box as opposed to the chat box, as it is easier to just check the one place for those questions towards the end of the session. But Bronwen should have time to answer those questions towards the end of the session. So please keep those coming. And without further ado, I'm going to hand over to Bronwen Jones. She is a wonderful colleague of ours and a senior practitioner in both the family team in Chambers and the immigration and public law team. And so we'll look forward to her knowledge and practice on this very topical and very important area of law. So I'll hand over to you, Bronwen.
Thank you, Sarah, for that very kind introduction. So as you will have known signing up today, the overarching topic today is local authority duties to non-British children. But I think it's fair to say that is an absolutely gigantic topic. It can cover anything from obviously unaccompanied children who may be unaccompanied asylum-seeking children, or they may be simply unaccompanied children subject to immigration control. It can cover children with families who are altogether subject to immigration control, children in families with some variation of British and non-British citizenship, children of families no recourse to public funds under a limited period of immigration leave, overstayers, and so on. So for the purposes of this of course, and of course overarching all of that is the local authorities' duties under Section 55 of the Border Citizenship and Immigration Act 2009, which initially when I prepared this I actually had a slide setting it out, but actually I decided practitioners are going to know about Section 55 and you can look it up for yourself if you don't know the exact wording. But obviously two of the most common scenarios in which this is going to arise are with, first of all, with an unaccompanied child, and secondly, with a family who are, for whatever reason, without recourse to public funds. So for the purposes of this seminar, I'm going to try and prune things down a little bit. It makes it a little bit bitty, and I hope you'll bear with me. It's my first time actually presenting this presentation, but I've identified as my topics the interaction of local authority support with asylum support under the Immigration and Asylum Act of 1999, which is no doubt a topic you'll be familiar with. And then looking into that, once you've established that local authority support is the correct form of support, or that the local authority might have a duty to provide that support, looking at the two of the specific types of support available under the Children Act 1989, which are available under Section 17 and Section 20. And also, and I'll be keeping an eye on the clock, but if I have time, a quick canter through provisions for young people who are leaving care. I mean, it's in the slideshow, and how I go for time will depend on how much time I take on it. And finally, just the discrete topic of age assessments, which of course are in many ways a threshold to receiving any of this support at all, because there have been some updates in the last year or so in a couple of areas of case law, one particularly important area of case law under age assessments. So looking first at asylum support, as you'll just to overview the basics, just to set our foundations, we have Section 95 support, which is obviously for people who are actually in the process of seeking asylum. They have a claim outstanding, and that includes their people in their family, their dependents. Section 98, which is interim support for asylum seekers who appears that they may be destitute, and that's pending the Section 95 assessment by the Home Office of destitution. And then Section 4 support, which is for any person who was but is no longer an asylum seeker who has had their asylum claim rejected. There are conditions for support set out under a statutory instrument, which is, I've given you the details there. Now, I've summarized it hugely. There are quite a few different bullet points of conditions, but basically it amounts to, are you leaving the country, or is that, so there is some very good reason that you're not, such as you've made an application for judicial review, it's not possible for you to leave, support being necessary to avoid a breach of convention rights, which I seem to remember from my time long ago volunteering for the Asylum Support Tribunal, usually meant that you had an application outstanding for judicial review and you needed to pursue it. So that's the asylum support framework. Then, of course, just to have it for completeness there, the destitution test, you will be aware, of course, that asylum support can be either accommodation or cash support. Well, I think it's not cash, is it? It's cards, or both. And that is a hyperlink, Assessing Destitution, which it's on the handout, which I believe the handout will be sent out afterwards. So you'll have the PowerPoint presentation. Now, in respect of asylum seeking families, when we're talking about the interaction with Section 95, the provision takes up the entire screen, but the answer is quite simple. If a family is in fact in the process of seeking asylum, then they can't get Section 17 support. It's expressly excluded by Section 122, subsection 5 of the 1999 Act. But I suppose it's convenient to note here, the local authorities can actually, it can be delegated Section 95 support to them. So the Home Office can make arrangements with different local authorities to provide Section 95 support through the local authority, and that's under Section 99 of the 1999 Act. Now, looking instead at Section 4, first of all, the baseline is paragraphs 2 and 3 of Schedule 3 of the 2002 Act, Nationality, Immigration and Asylum Act 2002. There is no prohibition on the provision of support under the Children Act, that is CA 1989, Section 17, to a child, or to the extent necessary to avoid a breach of convention rights. And obviously, convention rights might be Article 3, so in order to avoid destitution and a breach of the right not to be subject to inhuman and degrading treatment as a result of destitution, or it could be for Article 8 for various reasons, which could include the risk of a child being separated from their family because the family is destitute, then being placed in foster care, the risk of the child being forced to return to their home country and separated from broader family members who are in the UK, and of course the risk of losing the right of pursuing an application or an appeal if they're forced through destitution to return to their country of origin. But of course the question remains, when does Section 17 support kick in, shall we say, versus Section 4? And there have been multiple skirmishes in the courts, but I'm going to give you the headline case and the one that ended up deciding it all. Now, the considerations for the local authority when they're presented with a family who are claiming Section 17 support and they don't have immigration leave, and they say they have an outstanding application, for example. First of all, are they destitute? Are the children in need? And we'll come back to the topic of children in need. It's a technical term. It is defined under the Children Act. Whether there isn't any impediment to the kind of family returning to the country of origin. And this is something that some of you may well have seen. I know I have in social work Section 17 assessments saying they've come from a stable country, say they've a country with functioning social care and health system, even if it's not the equivalent of ours, and saying, well, they don't have an application outstanding. There doesn't seem to be anything preventing them returning to this country and avoiding destitution in that way. still on the proof thing, thank you. And then the last consideration is whether the case is obviously hopeless or abusive. So the key case that finally decided, after much debate between the Home Office and the local authority as to who should be responsible for failed asylum-seeking families, the key case, which seems to have settled the matter because it is 10 years old now, is on the application of VC and Newcastle City Council, which was a case of Lord Justice Munby, now retired, previously president of the Family Division of the High Court. And he said this is the issue for determination: which public authority must take responsibility, for providing accommodation and support to children in need within migrant families who are not entitled to support under Section 95 of the 1999 Act. So that is migrant families who do not currently have an outstanding application for asylum. And the case decided, as set out on the next few pages, but beginning at the next slide, is so sorry, could we move on to the, thank you. So the key points, first of all, just because they qualify for Section 4 support doesn't mean that the local authority is exonerated from assessing them, considering providing support and providing support if appropriate under the Children Act 1989, Section 17. And this is because levels of support under Section 4 and under Section 17 are different. Section 4 support is intended, it's described in the judgment as an austere regime. That is, it provides the minimum. It's intended to provide the minimum that is necessary to avoid a breach of human rights, to avoid a breach of a minimum level of humanitarian support, as it's described. Whereas the purpose of Section 17, it goes beyond that. It's to avoid harm to children, but more than that, it's to promote their welfare. And we'll come on to the way that it's phrased within Section 17 itself. Now, a key consideration for Lord Justice Munby in this case was that, unlike Section 95, there is no equivalent provision to Section 122.5. There is no provision for Section 4 support saying that where a family is available for it, the local authority is not allowed to provide support under Section 17. He said this is of central importance. And he said that it's to be inferred, therefore, that when both are theoretically engaged, and of course, whether Section 17 is engaged or not will depend on whether the child is in need. But where both are theoretically engaged, the more advantageous support regime, that is Section 17, will apply. Further considerations are on the next slide. I should pause here to explain. Poor Sarah she was hosting, which is normally a much lighter duty, but we've had technical difficulties that mean that the device I'm using won't allow Zoom on it, won't allow you to see both my slides and my face at the same time. So Sarah has to use the slides in order for you to see me, in order for you to have the delight of seeing my face at the same time as the presentation. So anyway, going on with VC key points. Where a person seeks support under Section 17, on the ground that the child's in need, therefore, the local authority in all cases, and this is just a blanket, in all cases where someone says we have a child in need, the local authority has a duty to assess. And then if they assess whether they're in need, they have to decide whether to provide services, and they can't justify not doing so on the basis of Section 4 support unless, firstly, they can prove that the Secretary of State is able and willing to provide support under Section 4, or can be compelled. But secondly, that Section 4 will suffice just to meet the child's assessed needs, and that means to lift them out of being whatever deprivation it is that qualifies them as a child in need. So moving on to the next slide. Therefore, it was essentially decided that Section 4 support is residual. So the local authority might be in great difficulty in establishing that the Secretary of State would be willing, could be compelled if Section 17 support is available. And given there's a very significant difference between the levels of support, it would be very difficult for the local authority to prove that Section 4 support would be sufficient to meet the child's needs. So therefore, in the general run of cases, it's very likely that if you're looking at a failed asylum seeking family that is destitute with minor children, the support is going to have to be Section 17 support. So just quickly looking at some other useful case law, which you can look at in your own time if you have cases bringing up these points. There's EAT and NEWAM, which it focuses on whether Section 95 support is available, thus excluding Section 17 support, because remember we looked at Section 122.5 that says where an asylum seeking family is entitled to Section 95 support, the local authority may not provide Section 17 support, and the local authority then has to decide, are they eligible for Section 95 support if they are not receiving it? Do they have an asylum claim outstanding? And that case looks at exactly in what circumstances a claim can be considered either expressly or impliedly to be an asylum claim, looking at the application form. Case of ES, it's necessary to take account of the Home Office's willingness to provide accommodation, but nonetheless, the local authority, even taking that into account, still has to carry out an assessment of a child in need when said to be in need. And MM and KN, which establishes that the in need assessment must be the local authority's assessment. It's not necessary for the court to assess that. It's a social work assessment. So then, yes, thank you. Looking at the support that is available. Now, there's a huge regime of local authority duties in the Children Act. It's in Section 3. And this is in England. There are different provisions in Wales, and I think there's an entire act, but I'm not expert in Welsh law in the area, but there's an entire act about local authority duties to children in Welsh local authority. So this is English law in the literal sense. But the most relevant duties that we're looking at here are Section 17, which is provision of services to children in need, and Section 20, which is the provision of accommodation. So Section 17, here we have, this is what Lord Justice Munby was talking about when he talked about the level of support under Section 17. It is the general duty of every local authority to safeguard and promote the welfare of children. So that's not just to make sure they don't starve, or just to make sure that there's a roof over their head, or they have the minimum sustenance available to survive, to avoid a breach of human rights, but actually to safeguard and promote their welfare. And so far as is consistent with that duty, to promote the upbringing of such children by their families, which again will become more important when we look at some of the other provisions, by providing a range and level of services appropriate to those children's needs. And paragraph 1 of Schedule 2 of the Act says that local authorities have to take reasonable steps to identify the extent to which children in their area, there are children in need in their area. Now, what is a child in need? This is the definition. He is unlikely to achieve or maintain or have the opportunity of doing so a reasonable standard of health or development without the provision of services. Or without the provision of services, his health or development is likely to be significantly impaired, or he is disabled. And so, particularly in respect of A and B, obviously, you may well have disabled children who are subject to immigration control, but without that, the first two parts of this definition, the focus is on how will this child fare in his life without the provision of services by the local authority. So with the services that have been identified as necessary. Now, some Section 20, yes, we're going to flip from Section 20 back to Section 17, but we'll focus on this for now. Sorry, Sarah, yes. So Section 20 is this slide. So every local authority will provide accommodation for any child in need within its area who appears to require accommodation. Now, this is a different duty. This is not about a family that is just destitute. This is about a child who has no effective parent. So there's nobody with parental responsibility. The child is lost and abandoned. The person who has been caring for them is prevented, whether permanently or not, and for whatever reason. Sorry, that last bullet point shouldn't be there, but anyways, it's a whole sentence, from providing them with suitable accommodation or care. And it's this last point in Section 20 that actually most often comes up in children proceedings adjacent to care proceedings, where you essentially have a local authority that is worried that a child's parents are not giving them good enough care. So they may, when it's on the cusp of care proceedings, with the parents' agreement, take the child into Section 20 accommodation. So it's not just about a parent being destitute, that's not enough. It's about a parent that's actually not providing good enough care. So yeah, so moving on the next slide back to look at Section 17, this is what underlines this difference. Any service provided by an authority to, sorry, I'm seeing questions come up, but we'll deal with those at the end. Any services provided by an authority in the exercise of functions conferred on by this section may be provided for the family or any member of his family if it is with a view to safeguarding or promoting the child's welfare. And also looking at section 6, subsection 6, services provided may include accommodation. So there actually is provision under section 17 itself to provide accommodation, but in that case we'd probably be talking about family accommodation to allow a child to be safely cared for by his or her family, whereas section 20 is about where really there's no family who can effectively do that. It also says they can give assistance in kind, which can include in cash. And the support under section 17 in cash terms will generally be above section 95 or section 4 support, which if I remember the last time that I looked at it was about 70% of benefits level, if I remember correctly, and section 17 will be more generous than that, although it varies from local authority to local authority. So these provisions underline that section 17 support is about caring for a child in need within his or her family. Now, section 20 continues to apply after a child has reached the age of 16, where the local authority considers that their welfare is likely to be seriously prejudiced if they're not provided with accommodation. So a child accommodated by a local authority for any reason under section 20, under a care order, either way, even under section 20, that child is a looked after child. And looked after children, there are particular duties and responsibilities that the local authority has to them, which are set out on the next slide. And you can see them there: social worker, a care plan, looked after children reviews, which will involve a range of professionals: social workers, health professionals, educational professionals. The parents will usually be invited, or any family members, anybody with parental responsibility. Personal education plan, they get priority admission to school, therapeutic support, obviously, if it's needed, and a health plan in all cases to meet any identified health needs of the child, which it could be from the trivial, small childhood ailments right up to very serious health needs. So local authority, even though Section 20 doesn't confer parental responsibility on them, they nonetheless take on quite a lot of duties that we associate with parenting a child effectively. Now, leaving care, let's check our time. I'll go through it quite quickly, I think, because obviously the title of the talk is children, but obviously we might be interested in young people as they move out of their childhood. So they have to have been in care for 13 weeks, looked after for 13 weeks in order to qualify for the leaving care provisions. And it has to have been in place at a certain age, and there are other conditions. There are duties that are under 23A to 24C of the Children Act. You can read them fully set out there. There's a whole panoply of duties owed to children leaving care, and generally they're available until the age of 21, but if the child is in full-time care, it's until 25. Now that's children in general. When we move on to look at leaving care for non-British children, there are conditions. So it only applies if the child actually has leave to remain. So either they've still got that discretionary leave until they're 17 and a half, and then that's been extended because they've made an in-time application, or they've got an appeal from that in-time application outstanding. Or under section 12 of the 2016 Immigration Act, that removes the assistance, but it also, so where they don't have a pending application, but there's an exception to that under Section 10B of the Nationality, Immigration and Asylum Act 2002, which was inserted by Schedule 12 of the 2016 Act. And there are exceptions, and one exception would be where the young person, the claimant, is destitute, and they're awaiting the determination of an application, which in that context, I'm taking that to mean an out-of-time application. So their discretionary leave has expired and they've made an out-of-time application, because if they made an in-time application, then they would still automatically be entitled to leave and care provisions. So here's some useful cases. An overall survey of pathway plans and what those are and what duties the local authority has are in A in Lambeth Borough Council. Then we've got the case dealing with the accommodation under Section 23C, which is where that duty falls in RSO, and then the issue of tuition fees in Kebeday, concerning a young person with extant leave, but no means to pay for university. And I believe the decision was not that the local authority did have to pay tuition fees, but that they had to give consideration to it. But nonetheless, it could be a useful case. So then moving on to look at unaccompanied children. So this is by way of coming into age assessments, but just to set up the scenario. When an unaccompanied child arrives in the UK, the Home Office has a duty to inform the relevant local authority as soon as it appears that they need to be looked after. And obviously, we all know children shouldn't be detained, particularly unaccompanied children, except in the most exceptional circumstances for their own protection, essentially. And you've got the authority for that in AN and FN. And this case concerned an unaccompanied asylum-seeking child. But as I said at the beginning, of course, not all unaccompanied children are seeking asylum. And what can be inferred from this case, it isn't said explicitly, but it can be inferred that this duty to inform the local authority of a child that needs looking after applies to all unaccompanied children subject to immigration control, because they set out the questions that the local authority, that the Home Office can ask on the first encounter. And they're quite limited. They're basically limited, as you can see, to biographical details. What's your name? When were you born? Who are your family? How did you come here? Have you got a passport? And that's understandable. If you're dealing with a child who's just arrived, they're a minor, vulnerable, potentially traumatized, you're not going to go into the entire screening interview process. So from that, but the questions that they're asking wouldn't necessarily disclose an asylum claim. There's nothing there about, are you afraid of anything at home? What are you afraid of? Why have you come here even? So it can be inferred that clearly this applies to any child arriving in the country without a clear right to remain, without leave to remain or nationality. So looking then at the issue of age assessments, these especially since Section 55 was enacted, these must be done at the earliest opportunity, because they're going to affect everything for this child, really. They're going to affect where they live. They're going to affect what services provided them. They're going to affect whether they can be detained or not for this young person, if they're a child or not. Obviously, we've covered that. They're going to affect if that opportunity is missed, the first opportunity to do that age assessment established they're under 18, then they might not be looked after appropriately, which might prevent them from being looked after for long enough to establish that they're a looked after child when they turn 18, and therefore entitled to looked after care provision. So they're going to have a huge knock-on effect if the age assessment is not done in a timely manner. And of course, we know that the substantive immigration decision will be affected by an age assessment, if only because there's that possibility of a grant of discretionary leave till the age of 17 and a half, whilst the child perhaps, whilst somebody responsible for the child works out what other applications they can make. So it has to be done immediately, and that's the duty on initially the Home Office. Now, so there are two stages to this, really. There's the initial encounter and the initial Home Office assessment, which, yes, is on the next page. And at that point, a decision should only be made to treat the claimant as an adult if So it says, if a local authority, Merton compliant, and we'll come on to Merton, compliant age assessment has been completed by a local authority, finding the claimant to be 18 or over, which the Home Office has agreed with after giving significant weight, taking all reliable evidence into account. Okay, so that's one possibility where a child can be treated, well, a young person can be treated as an adult. Or if this is on the initial assessment, it would have to be where 2 Home Office members of staff, and one of them, it must be at least Chief Immigration Officer or higher executive officer grade, have independently assessed that the claimant is an adult because their physical appearance and their demeanor very strongly suggests that they are 25 years of age or over. So it's challenge 25 in the guidance essentially now. And the third, of course, is if there's credible or clear documentary evidence. Now that guidance has changed. So the previous guidance, which is on the next page for you to see, is that an applicant is to be treated as a child unless 2 members of staff, CI or HO grade, assess that their appearance and demeanor very strongly suggests that they are significantly over the age of 18, and there's little or no supporting evidence for their claimed age. And this amendment to the guidance has also been put into paragraph, the relevant paragraph 55.9.3, as you see, of the enforcement and instructions guidance. Previously, that reflected the significantly over the age of 18 test, and now it's the what we can call the challenge 25 test. So it very strongly suggests that they are at least 25 years of age. And the reason for this is a significant case. So this is BF Eritrea. Now, in this case, BF was obviously an Eritrean asylum seeker, and he presented to a police station. He said he was 16. However, he was then assessed by 2 immigration officers, presumably at the appropriate grade, and they assessed him as significantly over 16. In fact, they said they thought he might be in his mid-20s. But the initial, they applied that test, that significantly over 18 test. They obviously did the Eurodac check. It came back to say he was a previous asylum claimant in Italy, where it was reported or recorded that he'd given his age as 26. So he was detained pending a return to Italy, but in detention, he was continuing to maintain he was under 18, he was a minor. And of course, we know that save in limited circumstances, it is unlawful for the Home Office to detain an unaccompanied child. So there were formal age assessments, 3 of them, and 2 of them found him to be over 18, but one of them said, no, he's 16, he's telling the truth. And so, of course, on the basis of that, the fact that he was in detention and he had an age assessment going his way, he applied for judicial review, and that was unsuccessful at first instance before the upper tribunal. So then it came before the Court of Appeal, which was a split decision. So we have Lord Justices Underhill and Baker, who decided that the previous guidance was unlawful because of that word significantly. And they said it was too vague, it was too imprecise. What you need is a margin of error. And they, if I remember correctly, they actually did make that comparison to when you go to a supermarket and you try to buy alcohol and they decide whether you look like you might be 25 or not. And if you don't, you have to present identification showing you're 18. And they said they need to quantify the margin of error. Now, they didn't say it had to be 25. They said we need a margin of error, that the Secretary of State needs to identify one, and then presumably, if necessary, the courts would decide if the margin identified was reasonable or not, whether it's sort of 5 years one way or another, 10 years one way or another, or as it is 7 years one way or another. However, Lord Justice Simon dissented because the guidance had already been amended in other ways to other bits of the wording prior to the case coming before the court. And he held that the word significantly, it wasn't imprecise, that was fine. And since the guidance had been amended, it was lawful. But obviously it was a majority decision, and so his appeal was upheld. However, the Supreme Court will be reconsidering that on the 16th of March of this year, before the Lord Justices Reed, Lloyd Jones, Sales, Hamblin, and Stevens. So we'll have to hold this place. For your use, those are hyperlinks again, the age assessment practice guidance for local authorities, Those are the practice guidelines that were relied on and approved in Merton, and we'll come to those Merton guidelines. There's also a very useful Association of Directors of Children's Services guidance document, Age Assessment Joint Working Guidance, which gives guidance on how social workers should carry out age assessments. And the detailed Merton guidance is as follows. The applicant has to have the purpose of the interview explained to them by the person carrying out the assessment, who will be a social worker. The decision maker should not determine age on the basis of the appearance of the applicant. There is really no physical way to tell for certain, and that includes DNA tests and it includes dental tests, which we'll come on to. But there's no physical way to determine for a certainty how old someone is. So the social worker cannot rely solely on physical appearance. And what they need to do is they need to do an interview. So they need to try and elicit some background information, family circumstances, if they can get an idea of what their home life was like, what they were doing at home, what that suggests in terms of the stage of development they were at, their history, their activities in recent years. And they must give reasons, and it says they should be adequate but not lengthy. So they've got to find that sweet spot somehow. If they make a negative decision, essentially it has to be reasons that the child understands or the young person understands for the assessment. And if they have any reason to doubt what the applicant is saying, and this is a fundamental fairness point really, they have to make them aware of it. They have to make them aware, you know, this is something that's going against your credibility. Can you explain it? Which of course is something that we see in any immigration interview if it's properly done. But here social workers have to do it in age assessments as well. And moving on to further points about the guidance, if they note any inconsistencies, again, they should be made aware. They must be given the opportunity to address those matters. And obviously there has to be allowance given for variation between different cases. Really how obvious it is that the child either is or the young person is not telling the truth. And they must make a decision, of course, vital, independent of any decision made by an immigration officer. So obviously this assessment has to be individual focused, young person focused, welfare focused, and it can't be driven by immigration interests of immigration control. This is a lead case on challenging a negative assessment. It's A in Croydon, and it set out some very useful principles. The first is, well, actually, I'm going to move down to the second bullet point, actually, because I think it makes sense to take it in that way. If an applicant seeks to challenge the decision, then the way to do that is by judicial review. However, looking at the first bullet point, it's not necessary to prove that the assessment is Wednesbury unreasonable or that any of the usual judicial review grounds of judicial review are necessarily engaged, because actually the question of age is an objective fact. Either they are this age or they are not this age. So the court has to make the final decision. So the court isn't just reviewing, the court is actually making a decision as to age, notwithstanding that it's a judicial review. And that's because, looking at the third bullet point, it's a precedent fact. So again, going back to the importance of getting an age assessment done and getting it done early, it affects this whole wide range of decisions about how this young person is going to be treated, both by the local authority and obviously by the Home Office. However, this is where maybe the judicial review standard of review comes back in. The better the quality of the original decision making, the less likely it is that the court is going to come to a different decision. And of course, the question of age, again, just underlines this point. It has to be determined before considering the question of needs, because who is going to be in a position to meet those needs and under what duties and what responsibilities will entirely depend on whether this young person is a child or is a young person over the age of 18. More useful case law. The local authority has to treat the claimant as a child until they are proven to be otherwise. They must revisit their decision if they are in receipt of relevant new evidence, and as it says can be in the bullet point, but actually in this case BM itself, they had refused to revisit a decision and that was held to be wrong. And finally, documentary evidence, probably elementary really, documentary evidence can establish age where you have a child whose oral evidence is, for whatever reason, unreliable. Again, quite obvious. Right, so on to the issue of dental assessment. So the door was opened, among others, in YB and the London Borough of Croydon, to sort of open this door to challenging an assessment by the use of dental x-rays. And many of you may remember back in late 2016, we had children arriving from Calais because the jungle was being closed, and there were issues around the Dubs Amendment and the number of children the UK was going to take in, children and young people. And they were actually arriving at the Eurostar terminal, and there was unfortunately a great, rather predictable stir in some corners of the press. And it went so far as a Tory MP saying that all of the young people who were arriving should be submitted to dental x-rays and to prove that they were children under the age of 18. Well, that's done now. That door has been closed. The relevant cases there are on the application of AS. And it considered dental assessments. It also considered the issue of the benefit of the doubt. So the next slide is dealing with the issue of the benefit of the doubt in age assessments. So there are two possible scenarios in age assessments. There's a scenario where a child is where the question is this young person over 18 or is this young person under 18? And then there's also a scenario whether for any particular reason it needs to be established whether the young person was a particular age at a particular time. Now, in the first scenario, the benefit of the doubt simply applies. It's the usual reasoning in respect of vulnerable applicants and vulnerable witnesses. It's an asylum-seeking child, it's an unaccompanied child. They may have documentary evidence, it may not have documentary evidence, they may be traumatized, they may not be able to call on anybody to corroborate them. So if the decision maker has any doubt as to whether this young person is over 18 or under 18, then they should find them to be under 18. The benefit of the doubt applies. However, if you're looking at on this date when they arrived, they were 16 and they were entitled to these services from the local authority. That's got to be determined. You can't, it's not a yes/no question. So it's not a matter of if it's one answer or another answer, you give them the benefit of the doubt and you choose the answer that's most beneficial. It's just a sympathetic assessment of what the child is saying, if that makes sense. I feel I got a bit tied up in my words there. Then points 3 and 4 in the head note are on dental assessments. And this is what it says, so that human teeth do develop as an individual progresses through childhood and into adulthood. However, that varies from person to person, from individual to individual, and even within different groups of people. I think there's been some discussion about in the case law about different groups of people whose teeth develop at different rates, but individuals vary. It's an individual assessment. So that's been put aside. And it's a matter, as it's noted, it's a matter of significant debate, how much you can tell age through dental development, because it varies so much from individual to individual. So that was noted, but it was also said that specific techniques which were put forward in this case as being, this is the way that you can tell the root pulp visibility and the mandibular maturity markers and the periodontal ligament visibility, they were found to be unreliable. So those shouldn't recur in future cases because it's not evidence you can rely on. And there was particularly negative judicial commentary on the expert who is usually relied upon in favor of dental assessments, which is Professor Roberts. And you can see this is really strong wording in a judicial setting, a strong tendency to overstate the value of research, overstating the weight of the validation, giving assurances about future conduct, failing to put them into practice. We regret to say that we did not on this occasion find Professor Roberts to be a reliable witness, and nor do we find that the mandibular maturity markers are of any use in assessing age. So that's it really for dental x-rays and age assessments. And in fact, the Home Office did give a statement to the BBC when they were covering this issue back in October 2016, saying that they don't use dental x-rays and relying on the British Dental Association, which has described them as inaccurate, inappropriate, and unethical. So yes, we finished in fairly good time, considering we started a few minutes late, for which I apologize. I think I'm right on my 45 minutes, more or less. So I'll look in the Q&A box. If an asylum seeker family with children are receiving asylum support, if they're going to be separated, then they can they seek LA assessment under Section 17? Yes. Yes, if the only reason the family is, well, first of all, if they're going to be separated, I'm not sure in what circumstances separated. If you mean that they're going to be separated because the child isn't being looked after properly, then only the local authority would be doing that anyway. So the local authority will already be involved. And the local authority absolutely should consider, if the only thing that is wrong with this family is lack of funds, then they should be providing those funds. Because again, we go back to Section 17, the necessity of children being cared for within their families, and the ability to provide services to that family. And that really does, I mean, it does mean, it means providing accommodation for mum and the children. It means providing money, not just for food for the children or for their clothes, but it means providing a family in which the electricity bills are paid and in which mum isn't dying of hunger, but she has enough energy to look after the children. So this is why Section 17 goes so much beyond what Section 4 does. Wouldn't you say the local authority has any responsibility? Oh, I've been getting this recently. There's a case about this, which I don't have to hand, but there was a recent case. So the question is, would you say that a local authority has any responsibility for resolving a child's immigration status whilst the child is in their care, such as where children are entitled to apply for indefinite leave or citizenship? Yes. I mean, in respect of indefinite leave, I would say it's incontrovertible. Yes, absolutely. If the child is in care, there are no cases on this, so I'm hesitant to use the word negligence because I'm not a civil lawyer, but it's a dereliction of their duty. It should be part of the pathway plan. It should be part of the LAC reviews. Does this child are they regularized? And are they regularized to the extent they can be? Now, in respect to citizenship, it gets a bit more complicated because there was a recent case about children who were Indian nationals and had ILR. And if anybody knows that case and can put it in, I'd be very grateful because I can't remember the citation or the name right now. But I know that they were Indian nationals. And so there was consideration being given to apply for British nationality, but India does not allow dual nationality. So they would have lost their Indian nationality if British nationality had been obtained for them. And that case held that social workers need to check and do research and maybe in some circumstances ask the courts before they apply for British nationality for children in their care, because they need to know what the ramifications of doing that are, which, I mean, it's terrible to social workers. They're not immigration lawyers, and they're, local authorities are stretched as it is. And now we've got this kind of damned if they do, damned if they don't. But certainly, they should be getting them indefinite leave to remain. And of course, in many cases, you won't be facing this dual nationality problem. You're just facing that situation where a child is entitled to British nationality, which in some circumstances may be a time-limited entitlement, as we all know. And if it isn't done in that period, then they lose that opportunity. So unfortunately, I think it has to, the bottom line has to be local authorities have to find the resources. They have to hire some of us to give them advices in individual cases as to what should be done for the children. And of course, local authority decision-making will take into account the wishes and feelings of the children themselves, more and more so as they get older through their teens. Now, I think there were some questions also in the chat box. I'm just going to close the Q&A and have a look at the chat box. Right. Okay, so I've seen there's a question saying, do asylum seekers children have to be disabled first before he's entitled to preventative destitution? So that's obviously, sorry, I obviously confused matters with the way I went through Section 1710. Being disabled is only one way in which a child might be in need. They would also be in need if they're not essentially likely to be safeguarded, or they're likely to suffer detriment to their health or education if services aren't provided to them. So no, the child of asylum seekers or the child of irregular migrants or a child without leave or a child subject to immigration control does not have to be disabled to be entitled to Section 17 support. It is enough if they're destitute. It is enough if that is placing them at risk of harm, essentially. I see a question saying, is this the same for those of care leaver age? And I'm not sure what that's referring to. Is what the same, but apparently it was answered online. So thank you, Annie. And I think I answered about DNA tests and age assessments in the course of the presentation. There's no physical test that can be done that can say for a certainty how old someone is. And that's why it needs to be the subject of a careful and sensitive social work assessment. Oh, more Q&As, or is that answered? Oh, well, they're still live, these two questions, but I've answered those. So if anybody else has any questions, please do pop them in now. We'll wait a few minutes. And in the meantime, thank you all very much for attending.